Welcome to the Crime Redefined podcast, produced by Zero Cliff Media. Coming to you from the US Bank Tower, high above downtown Los Angeles. In our podcast, we drill deep into forensics and criminal investigation from the viewpoint of the defense, as well as explore the intersection of the media and the justice system.
On this episode of Crime Redefined, we are excited to present another book author interview. Donald McInnis is the author of She's So Cold: Murder, Accusations, and the System That Devastated a Family. He was the attorney for one of the wrongly accused teenagers in the murder of Stephanie Crowe and is here to tell us what went wrong in that case.
On January 21st, 1998, Stephanie Crowe's grandmother awoke at 6:30 in the morning to the sound of her granddaughter's alarm clock. As she entered Stephanie Crowe's bedroom, she observed the horrific sight of Stephanie lying on the floor, covered in blood.
Stephanie's dad, Stephen, and her mom, Cheryl, soon ran to the bedroom to witness the devastating sight. As Cheryl Crowe held her slain daughter's body, she cried, "Oh, Mom, she's so cold."
A nightmare then ensued for the entire family, but not just one of grieving for their loved one. The police, believing that the house had been secured and the murderer must have been one of the occupants, very early on focused their attention on Stephanie's 14-year-old brother, Michael, as their prime suspect. After all, Stephanie's dad was clearly distraught, but Michael had a perceived lack of emotion.
Ultimately, through highly suspect techniques, the police coerced false confessions from Michael and his friend Joshua Treadway. A third 14-year-old, Aaron Hauser, was also falsely implicated in Stephanie's murder.
Thanks to DNA testing, the boys were eventually fully cleared of Stephanie's murder, other than the emotional scars that they would have to bear for a lifetime.
Now let's hear from Don about how such a travesty could occur. Tell us what motivated you to write She's So Cold 20 years after the murder of Stephanie Crowe.
It was one of the cases that kept showing up as the years went on. That was because of the trial and then appellate hearings and then the order of a new trial for Richard Tewitt, the vagrant, the schizophrenic, mentally bothered vagrant. But more importantly, each time that I saw that Michael Crowe had to come down here and testify, and that his mother and father had to come down to San Diego and testify, and the agony in their face, I realized that because of the police investigation and the technique of interrogation that was used, that these people were living a hell that would not go away, and they never got closure from the death of their daughter, Stephanie. So I wanted the public to know what happened when the police interrogated the three boys, and I wanted them to know what the evidence was and how the police and the district attorney's office mishandled the case. So that's why the book was written.
Don, Summer Stephan, the DA on the Crowe case, is of course now the DA of San Diego County. I was curious, how about the other attorneys and police officers involved in Crowe? Other than you, are any of them still active? Paul Blake is semi-retired. Mary Ellen Attridge, she retired just about 5 months ago. And the police officers, Ralph Clater, he was the main detective that handled the Crowe murder case. He retired shortly after the whole thing blew up. One of the other officers, Chris McDonald, he was the one that gave the computerized voice stress analyzer test. He received several honors and accolades for the work that he did and how he used that test to manipulate the boys into confessing. Barry Sweeney never really played that much of a part. He was with the Escondido Police Department. McDonough was the Oceanside Police Department. Barry Sweeney, I lost track of, so I don't know what happened.
I was going to say, you mentioned the boys. Give us a quick overview of the three boys at the center of the case and what the prosecution alleged each one's role in the crime was.
Well, the boys were freshmen at a high school in Escondido, and each one of them was extremely bright. The brightest was my client, Aaron Hauser. Michael was extremely bright, also, Michael Crowe. Josh Treadway was a normal kid, normal high school kid, probably not quite as high an IQ as Aaron and Michael, but he was very, very much a wonderful kid, very gentle kid. He loved to draw. He was the artist in the group, and he maintained a very enjoyable running diagrams of the people involved in the case, in particular Summer Steffens, complete with horns at times. Michael was 14, Josh was 14, Aaron was 15 years old. Aaron was considered by the police, because of his high IQ and intelligence, to be the mastermind and the killer in the group. They always looked at Joshua Treadway as the lightweight, as the kid that they could break and get the most incriminating statements from. Michael was traumatized by the entire scene of his sister being killed, and was very vulnerable. And even though he was intelligent, a very high level of intelligence, he broke and gave the incriminating statement that he did, which was a handwritten letter to his dead sister, and basically apologizing for her death. Now, the way the police theorized it worked is that the boys walked over to Michael's house, the two boys, and Michael let them in. Joshua stood as supposedly, according to the confession, but it changed as time went on, as the lookout, and then Aaron went in and did the dastardly deed. Josh eventually admitted that he was inside the house.
What was your first impression of Aaron and his family?
He was just a wonderful, wonderful client. I asked him to do the impossible. Whenever you have a juvenile that is being held on a serious charge, the authorities try to put them in with another roommate, who then tries to get some sort of confession from the client. So I asked him to be put in isolation, and he did that for 4 or 5 months. He held up in isolation, and that's really hard to do. It got so bad that, as in the book, I tell a story about I would pay him $1 for every sit-up that he could do. And that's how he tried to break the monotony and the trauma of being basically locked up and isolated. His mother, Mrs. Hauser, she was a school teacher, an elementary school teacher. His dad, they were divorced. His dad was in, I believe, the solar panel business. Aaron had an older brother.
So they were really like any typical all-American family.
All three were middle-class, all-American, God-fearing families. Joshua Treadway's family were extremely religious. And so that's why them breaking Joshua after nearly 18 hours of interrogation spread over 3 different sessions was such a shame, because he just really, it's hard to explain the torment that he went through as he realized that what he said and what he admitted to was going to ruin the lives of all 3.
Well, Don, I'm sure you would agree that all good lawyers would advise that when you were arrested or contacted by cops, that you shouldn't speak with them until you have legal counsel. But why is that particularly important for minors?
Well, you got to understand the juvenile mind. Towards the end of the 20th century and for the last 20 years, science has shown that the juvenile mind is not fully developed. In particular, the frontal lobe sections of the brain, which are absolutely necessary for controlling how the judgment is exercised, for controlling emotions, for controlling the inability to think long term, is missing. They only look for short term. And these brain scans have been able to determine that the children, because of that, number one, developmentally, they cannot and do not understand the Miranda rights. Number two, which is really important, they look at just one thing, going home. And they're in an adult world where the adults are always telling them what to do, so they are very pliable and acquiescent to any police officer. On top of that, they're told as young, very young children, that if there's anything that happens, go to a police officer. They will protect you. So these children, because of their mental development, lack of experience, and particularly in regards to the legal system, were just extremely vulnerable. Now, the mind develops all the way up through about age 25, in particular for males. So the brain of an 18 to 25-year-old in many instances is as bad as a 14 to 15-year-old child. And you put them in an isolated, windowless room and interrogate them for hours at a time, you lose about 20 to 40% of their ability to exercise judgment, whatever level it was before they started because of their age. So children are vulnerable. And that's why in my Bill of Rights, I particularly emphasize the need to have the adult involved, the adult family member or guardian, and to have an attorney present.
You know, speaking of that, how do you feel that the Oceanside and Escondido PD took advantage of that? What were some of the rules that were violated during the interrogation of the boys?
Well, the law looks at children as though they are adults. They are subject to adult laws. They are subject to adult procedures. So there is nothing that at the time and then subsequent years in California since that indicates that children have a right to talk to their parents, or that the police have to call and tell the parent that the child is present. That has only changed recently, this year, in fact. So the bottom line to it is you don't have to tell the parents of any child, and they didn't in this Crime Ritter case, that their kid was being interrogated. Or police can go to the school, pull the kid out of class, and interrogate him right there in the school cafeteria or office of the dean. So these children are very vulnerable mentally and emotionally, and are very compliant to whatever the police want them to say.
How did the Oceanside and Escondido PD exploit that? Is there anything specific that stood out to you?
Oh, well, in regards to the interrogation of Michael and Joshua, they were full bore. They followed the Reed technique of interrogation to the letter of the law. They involved Dr. Bloom, who was a police psychologist, to analyze the children and tell the officers how best to break them down. During the interrogation of Michael, there was a Deputy DA Hoover who was present at the time and advised them on what to do. And when it came to Joshua, they got the same advice, further advice from the Deputy DA Hoover. And that's why they were able to interrogate him without Mirandizing him. And they eventually sent him home, let him cool off, as they say in the law, so that the influence of being in police custody was gone. Went back a couple of days later, talked to him, seeing how he was doing, making sure he was staying home under supposed confinement at home, and then went and got him and brought him back, asked him without Mirandizing him if he was going to change his story. He said no. And then they Mirandized him and took his deposition statement and confession. So the bottom line to it is they had advice from the police, from the district attorney's office. They had advice from a psychologist in regards to how to manipulate these kids and take their statements. That is what stands out.
You know, this really sounds like the boys never had a shot. The deck was really stacked against them.
No, the boys never had a chance. Even Aaron Hauser, who figured out after the police searched his house with a search warrant that he was a possible suspect, and then they turned around and did a controlled call with Joshua, and Joshua tried to get him to admit that he was involved in the death of Stephanie, was the planner of how to do it, and was the actual executioner. Once they did that, by the time they picked him up and brought him in, he was very resistant to all of the manipulation techniques that were being used, the psychological maneuvers that they tried on him. So in desperation, they said, well, look it, you're a smart guy and you follow a lot of games that involve killing people, shooting up places, war games, things like this. Tell us how you would use a knife to kill somebody. And they played on his ego and his ability to play games. And they got him to give a statement in regards to how he would have used the knife to kill somebody. And that statement, well, it was kept out. I was able to keep that statement out, but if he ever took the stand, and depending on how much I allowed him through his testimony to open the door, they could then bring the statement in and say that this is exactly how Stephanie Crowe was killed.
You mentioned the Reed technique. Is what you just mentioned part of that? And if it's not, can you tell us more about the Reed technique of interrogation?
Yeah, actually, it's laid out in my book. I have two objectives in writing the book for the families, but the third objective was to inform and let people understand a little bit about what the methods are used by police to interrogate an individual. The Reed technique is broken into three segments. Segment one is what they call the investigation or gathering of evidence. And what they want to do is go through and discuss, interview everybody, observe their movements and techniques, and then they come back and they have a discussion as to who they think is telling the truth and who they think is not telling the truth. And that is based upon an analysis of body language as well as the spoken word and how it was said and the emphasis that was placed when the individual is answering questions or describing how the event as they have perceived it to have occurred. The most important section is the actual interrogation. And by the time they begin the interrogation with the Reed technique, they are focused and convinced that the individual is the perpetrator of the crime. Step one is what is called a direct confrontation of the suspect. That means they just come right out and in closed statements say that you killed or you stole or you did this. And they do not allow you to ask questions. They say they have the evidence. You are the perpetrator, even though you may not have any evidence. As in the Crowe case, there was no evidence. Step two is, as they are
confronting the accused, they attempt to develop a theme as to why the accused would have done what he did. You stole because you were hungry, or you killed because that person was trying to harm you and you were fighting in self-defense. The theme is very important because it has two results. The first result is it allows the suspect to perceive that what they have done is morally justified or mitigated by the circumstances of their actions and why they did it. And the second one is it raises the prospect that because of the mitigation of the events, as you are being said that you did it, and this is why, you think that you're going to be treated less seriously by the court and the sentencing would be less painful. The third one is to handle denials. Every time you have a denial, this is the third step, every time you have a denial, what you want to do is, as the investigator, is to shut them off. Don't even let them state the denial. The evidence does not say and support what you're trying to tell us. Is how they teach them in the different classes that these police officers go through. In other words, psychologically, the person cannot hear themselves actually giving a defense and the reasons for their defense. They are shut down. They are prevented from going through. The fourth step is to overcome any objection that is made by stating that the evidence is totally contradictory, such as, well, your co-defendants said you did it, or that the physical evidence, the DNA evidence exists that shows that you did the crime. And at this point, normally, after all this confrontation and lying to the defendant, in many cases, they find that the individual begins to break. And when the individual begins to break and cry and cannot reason, they have to retain or improve that suspect's participation. They got to bring them back somehow. And in doing that, this is the time when the good cop, bad cop routine is usually played. Some person will come in, sit with them, touch them, tell them they're not a bad person, go through the theme of why they did it, and tell them that the society will understand. The sixth step is the handling of the suspect's passiveness. This is all part of him shutting down. And what they're really attempting to do is to get the suspect to re-engage with one or more of the detectives. And when they are able to bring them back, to calm them down, to give them something to drink, to show compassion towards them, then they try to take them to the seventh step, which is the presentation of alternative theories. And this is, again, re-emphasizing, this is the face-saving thing, where they again re-emphasize you needed the money in order to feed your child, or you didn't plan the crime, it just happened instantaneously. At this point, they should have the suspect to the point where they have confessed. But that's not good enough. You must, under the Reed theory of technique, get them to confess to elements of the crime that you know and can prove, thereby giving validity to the confession, because the confession is going to be challenged by an attorney like me, who is going to say you coerced it. So the more accurate the confession is in regards to what evidence is known to exist, then the higher the validity and the less likely that a judge will say it's been coerced. Besides, the guy is guilty because he knows all the details of the crime. The final step is a written confession. And why is a written confession important? Reed
teaches this time and time again. That's because once the accused is out of the influence of the detectives, is either in custody or meets with his attorney, he will recant the confession. A written confession, therefore, is needed. And once you get it in writing, you can waive it in front of the jury and the judge as proof that he did the crime. Now, the flaws that exist in the Reed technique is that it's all based upon the assumption that the police officer has the ability to know when the suspect or the accused is lying. And that has been shown time and time again by scientific evidence that it's about a 54 to 46% accuracy at the most, and that's generous. And that's pretty much a flip of a coin. Anybody could flip a coin and say you're lying or you're not lying, you're telling the truth. Because once they start the accusatory process, it's a closed-ended process under the Reed technique, and it will not stop until you confess or shut down and say, I'm not going to talk to you.
Interesting. I want to key in on the ability to detect a lie. Another item in the detective's bag of tricks was this so-called computer voice stress analyzer, or CVSA. Can you tell us a little bit about how that works or doesn't, and what your opinion is of the validity of any data that comes off that instrument?
My opinion is it's a bunch of bullshit. And I'm sorry for such direct language, but the science behind it is extremely shaky. It's based upon voice inflection. How you they're saying that if you are lying, there'll be all sorts of voice inflections that will occur, and then when these occur, they can be printed out and read. What the McDonough did from the Oceanside Police Department, he was the technician and the one trained in the CVSA. What he did, though, was he basically lied. He said that every time Michael took the test and Joshua took the test, he said it proved that they were lying, that their denials were false denials. So as a consequence, it's like taking a lie detector test, and then no matter what you say or how you deny or describe what occurred, the technician can come back and tell you that the machine says you're lying, and you won't know the difference by looking at it anyway. The sad point about the CVSA is that it is used by the federal government in certain circumstances when it comes to employment and other internal security issues. But the accuracy of it is challenged, and we were prepared to really go after it.
I had a question about that. Are these printouts that come off the CVSA, are those discoverable to the defense?
If they keep it. I mean, why keep it if you are using it as a tool to extort a confession?
So we had the coerced false confessions, and it sounds like in Crowe, the prosecution also attempted to tie some physical evidence in. One of the items was the so-called murder weapon, the best defense knife. I know that they ran some, quote, scientific tests on it, and I'm curious what they tried to argue based on the results of the testing on the knife.
Well, when it comes to the use of a knife, there's two ways that you can say that that is the murder weapon. One is the width of the blade and how far in the knife goes. If the knife is plunged all the way in to the hilt, it will leave bruises where the hilt compacts and compresses against the skin. In the best defense knife, as you will note in my book, there's a picture of me holding it. And the only way that you could use that knife to strike overhand, because of the way the grip is on the knife, you just would not leave the same hilt, bruises, and marks. More importantly, it is a knife that is used to fight not in an overhand position, but basically the knife could not make the same types of cuts and depth penetration if you hold it in an overhand position. You have to hold it in a fighting position where the knuckles are down and the blade is down and you are stabbing straight forward. Or you reverse it and hold it so that the blade is outward and the top of the blade is against your wrist and forearm as you grip it in the traditional SAS fighting position. That's the British form of our SEALs and Green Berets. So the knife wasn't the murder weapon. And what they tried to do was to take the knife and use a cadaver and try to say that they were able to get the same penetration with the same width of the blade. And it would have been blown apart in front of a jury. There was no way to do it.
And Don, did I read correctly that they also did some presumptive testing for blood on that knife?
Yeah, but they didn't find any blood.
So it came up negative?
Yes. Oh, by the way, let me add one more thing about the interrogation techniques. The American system of interrogation is an accusatory system, period. It has always been an accusatory system. The way they verified the confession was to extract it by beating the person or hanging them. And when the courts ruled in the famous case in Mississippi, that you cannot admit, that was in 1936, you cannot admit the confession that is administered by force, such as hanging, beatings, torture, things like this. They then went to what's called the third degree, where you shove the head into the toilet, you shine the light in their face, and you strike them in places where the bruises won't show. And the famous case of Miranda versus Arizona, the court acknowledged that the third degree and torture had been replaced by psychological interrogation. And therefore, they were at a crossroads and rather stymied on how they could determine that if confession was coerced if they didn't have physical proof of torture. So that's why you got your Miranda warnings, that you have a right to remain silent, that you have the right to an attorney, that anything you say will be used against you in a court of law. And then if you cannot afford an attorney, one will be provided to you. These were made into law as an effort to stop and control and limit the abuse of psychological interrogation. In fact, the court in Miranda said that we recognize that a coercion can occur with physical abuse and mental abuse. And therefore, that's why they had the Miranda warnings. But for a juvenile or a person that is not very smart, is not intelligent, or is not fully developed mentally, up to the age of 25 is the general recognized age where the judgment factor sets in and they can make intelligent decisions. Miranda doesn't work. That's why I recommend in the book for children that they be continually asked if they want to talk to their parents before they talk to the police. And in that way, you get an adult into the process of interrogation. More importantly, under the Bill of Rights,
children under 14 cannot be interrogated unless they talk to an attorney and the attorney agrees they can be interrogated. And if the child is 15 to 17, they still have to talk to an attorney before they can be interrogated. In other words, the adult professional steps in to protect the child who is totally helpless.
I really felt that in your book where you talk about the improved Miranda rights for juveniles, that it was excellent and hopefully something will come of that. It was really well done and had some great suggestions for law enforcement.
It's so logical. I mean, what parent can tell you that their child knows what the hell they're doing when they're 14 and 15?
Don, can you take us inside the home and tell us about the issue of whether Michael would have seen Stephanie's body at 4:30 a.m.? The prosecution put a lot of weight on this, and I just wanted to get your take on the evidence.
Sure. If you walk down the hallway from the kitchen, you will, there are bedrooms to the left and to the right, but there's alcoves. In other words, the door isn't flush with the hallway. It's set back about 3 feet. And so if there is a body that's in the doorway, it's at least 3 feet, about 2.5 to 3 feet, could be even 3.5 feet if it's set back as Stephanie was. Because after she had been stabbed several times through the comforter that she had over her, she got up and crawled trying to get help. And then she passed out somewhere inside her bedroom by the door opening where the alcove is set back. So when Michael got up, the only light that was on was, I believe it was his computer or a TV light. I can't remember right now. You're getting me on some details here. But it was a faint light, and it did not illuminate out into the hallway in the way that the DA tried to make it. So when he got up and walked out, he walked right by the body, went to the kitchen, took an aspirin because he had a cold, and some water, and consumed it, went back to the bedroom. To show you how far back she was in that alcove and how hard it was to see the body, in the morning when the alarm went off for the grandmother to get up, it was an alarm that went off in Stephanie's room. So the grandmother got up, put her robe on, walked out into the hallway, down the hallway, and walked into the alcove. She didn't see the body. She stumbled against it, then turned a light on and saw Stephanie there covered in blood, which she said was she's covered in something brown. So the only evidence that the police and that the district attorney could connive is, well, anybody would have seen the body there. That's not true. And even in the final position of the photographed body, when the police got there and photographed it, the body had been moved. It had been moved by Dad and had been moved by Cheryl, the mother, when she picked the child up. In fact, that's the sad part of the whole thing of that murder scene, is that Cheryl Crowe kept trying to warm her dead, cold child by rocking back and forth and hugging her. But the body had been moved by the time the police had gotten there. In fact, it was moved after they pried Cheryl from the child, and the paramedics then took over.
Don, I read that at some point before Treadway's trial, the prosecution attempted a crime scene reconstruction on that issue, and that it did not come out in their favor. Is that true? And if so, how was that discovered and used to the boys' benefit?
It was never used by us. It was done by them, and it was kept under wraps. We found out about that after the case had been dismissed. You must understand, at the time, when you are a juvenile,
you are to be tried in juvenile court. There is what is called a Welfare and Institutions Section 707 hearing, in which a juvenile judge will sit and determine whether or not you will stay in juvenile court to be reformed or be sent to criminal court to adult court, where you will be tried as an adult. The difference is staggering because you can be released from juvenile jurisdiction as early as 18 and up to 25 normally, 25 years of age. Whereas for this type of crime that the boys were facing, the charges that were brought against them, they were facing a life sentence. So we weren't ever aware of at the time, and nor planned to use it, because that is all part of the work product of the DA anyway.
What was your opinion on the significance or lack thereof of the kill writing found in Stephanie's bedroom?
Oh, yeah, there was the word kill that was etched into the sill of the windowsill of her inside her bedroom. They tried to make out that it was Michael's handwriting, but they were never able to find anything conclusive in regards to showing that it was written by him or carved by him into the windowsill. One of the themes that the district attorney wanted to play up, and that what the police also emphasized, was that these kids were into Dungeons and Dragon phenomena type of games. There were just several other types of games similar to Dungeons and Dragon, where people are killed and stabbed, shot, things like this. Michael wore black all the time, so he was looked upon as someone that the police couldn't relate to. He wasn't a football jock. He was a brain. He was a very intelligent kid who, frankly, never had to study much for any of the classes and aced most of them, except for his last semester before the murder, because he was bored with his classes as a freshman. So the word kill, I don't know who put it there. It could have been Stephanie. Kids that age were very much into Dungeons and Dragons and other types of games, but they tried to use that as a pretext to describe these kids as malevolent and dangerous and murderous.
Another question about the crime scene. Don, it seems like one of the, quote, facts that the prosecution put forward and that led them down the wrong route was that the house was secure, nobody could have got in, and therefore the murder was an inside job. But in reading your book, it sounds like that's not really the case. What was the actual condition of the doors and windows in the Crowe house that morning?
Well, in the master bedroom, there was a slider, but it was off track. So you couldn't move it without making a tremendous amount of noise. And they also had these blinds that would have rattled and made noise. So the police came to the conclusion that the murderer would not have come in through the master bedroom where Stephen and Cheryl Crowe slept. They then went around to the main entrance. What you've got to understand is the house is like a rectangular pointing north, with the front living room in the north with a pool outside of it. To the south was the garage and the kitchen where you would enter through a door. And there was a door actually with a light over the top of it that was at the south end that entered into the kitchen area. And they felt that door was locked and secured because the grandmother said that she told her son, she had another son, Mr. Kennedy, to lock the door. The main entrance, therefore, is on the east side of the house, midway between the north end and the south end of the house, of this long rectangular house. And the police felt that there was no way that was broken into or used as an entrance, because it was full of cobwebs and spider webs. And therefore, as a consequence, they were all intact, showing that no one had ever opened the door for a long, long time. They then looked at all the windows and came to the conclusion that the windows were not forced in any way at all, and they saw no evidence where someone would have climbed over the window to get into the room if the window had been open. So it was their conclusion that the place was secured and that no one broke in or forced entry into the house. Their mistake is that Mr. Kennedy did not have a key, so that you have a deadbolt and a door knob that locks. There's no way he could have done the deadbolt, because he didn't have a key in order to lock it as he left. So all they had was a door at the south end next to the kitchen. That the deadbolt was left unlocked. And number two, the button, or the twisting button to lock it could have been forced, which Tuitt tried to do several times following this particular murder scene, when he was chasing following these young girls. So the house was not secure. In fact, the deputy had been called to the area because the minister found him, Richard Tuitt, trying to peer in through windows and shaking doors, and even walked into a trailer that had the daughter and the boyfriend of the daughter of the minister that was living there, and had to be chased out of the trailer by the boyfriend. So the cops came, they drove over, saw nothing really unusual at the minister's place, drove up the road several hundred yards, came into the driveway of the Crowe house, and as they did, they saw the door being shut, that door that goes into the kitchen being pulled shut. The officer sat around, looked at things, figured that there was nothing wrong, and drove away. That person, in my opinion, that had pulled the door shut was Richard Tuitt.
You already covered some of it, but can you tell us a little more about Richard Tuitt and what his activities were around the time of Stephanie's murder?
Yes, Richard was a mentally disturbed young man. I believe he was schizophrenic. He was off his meds, hadn't shaved for months. He had a long beard. His clothing was a mess. He had a red top and a white T-shirt underneath, long pants. And he was in the area looking for his what he called his girlfriend, Tracy. Tracy, by the way, is very similar in appearance to Stephanie. And he went to the place where the residence where she had been, and he had done drugs with her before, and she wasn't there. He then walked around the area, went up this long driveway. The Crowe house is on the west side of Highway 15. Not Highway 15, Valley Road. And it's a T. It goes up and dead ends. And if you go to the left, you go to the minister's place. If you go to the right, you go to the Crowe house. And I told you what happened, how he tried to get into the minister's house, and how he walked into the trailer, which was on the minister's house, where the daughter and boyfriend were. After the murder, he then proceeded to try to follow some girls that were riding a bus in Escondido. in the Valley View area, and he followed them to their apartment. And once the girls got inside, they locked the door, and he tried to shimmy the door to get into it. And they were, of course, panicked and called the police. And Tuitt was arrested for that. In fact, he was prosecuted for that and was given jail time for attempting to burglarize the house. There was another occasion where he was walking around and he saw some people and he followed them home, again, young ladies, and he was shooed off by one of the mothers.
And Don, I understand that initially Tuitt's white shirt was found to have his own blood on it, and there was no blood on the red shirt. Tell us about the back and forth you had with Treadway's attorney, Mary Ellen Ettridge, regarding the strategy of conducting independent defense DNA testing on Tuitt's shirts.
Well, first of all, the crime technicians and the head of the crime lab for San Diego County didn't see any blood on the red shirt nor on Tuitt's T-shirt. And in fact, that particular person testified at the trials of Richard Tuitt and was emphatic in that there was no blood on the red shirt or on the T-shirt. What happened? Here's the problem. If we went and tested Tuitt's clothing and it came back with no DNA evidence connecting him to Stephanie, we would lose our only theory of defense of who killed her. So if we tested that clothing and it came back negative, now we were stuck with the written confession of Michael and the verbal confession of Joshua. So it was a huge decision to make. I discussed it several times with Mary Ellen Attridge. She wasn't interested. Too risky. Would eliminate the phantom person that we could point a finger to that we could say was there, was in the neighborhood, and had the mental condition where they could do the murder. I talked this over several times with Aaron. We had long, long discussions about this. And finally, he said, I didn't do it. I didn't kill her. It wasn't me. Let's test the clothing. So as trial was beginning on Joshua, Mary Ellen was the defense attorney for Joshua. I told her I was going to make a motion to have the clothing done if she would not go along with me. And I told her, I'll give you a day and a half to 2 days before I file the motion. And she said, let me think about it. 2 days later, while we were in court, she announced to the judge that a stipulation had been reached between Summer Steffens and her to have the clothing of Richard Tuitt tested, and that it would be sent to the laboratory that I had suggested, which was the Berkeley Laboratory up in San Francisco Bay Area. So I got my way, but I certainly didn't get the cooperation of her on it. And the clothing was sent up there. They had the most advanced DNA testing at the time in California. That's how that came about.
It sounds like all of this happened on the eve of the trial. Tell us how and when you first found out that the lab had found Stephanie's blood on Tuitt's shirt and how that made you feel.
First of all, the trial had not started when I told her that I would file the motion. We were still in pre-motions and other arguments before the judge. The clothing was sent up there. I think it was about a week and a half passed at that time, had passed, and the trial was about to start with Joshua. I believe jury selection was taking place. They were in Vodire. When the news came down, I got a call from Mary Ellen at night telling me what happened. And of course, I congratulated her on brilliant tactical move. Well, I had what you don't know is how do you defend a case in which your client is being charged for murder and two of his supposed accomplices committed the murder? What do you do? Well, there is a lot of things that are non-legal that you do. In her particular case, I put her up front and made sure she was in front of the camera every time we stepped out of court. And I made sure that she would deny the guilt of the boys and that the confessions were coerced, because every time she did that, she would hear herself say it. That did not stop the district attorney from making 3 state's evidence offers. The last one, about 2 to 3 weeks before trial was to begin, was no jail time for Josh if he would affirm his confession. So not only did I do that with Mary Ellen, make her the focal point and the star before the cameras, and take the back seat and just stay away from the cameras as much as possible, but I also did one other thing. Remember that the Treadways are a very religious family. There were about 50 people. I called them Aaron's Army. And these were the people that supported Aaron. And I discussed with his mother and Aaron that we had to make sure that Michael's family and that the Treadway family were also included in the community support for the boys. So the mother and the father, Cheryl and Stephen Crowe, were made part of the group of supporters of the community that attended every hearing, every single hearing, and also the same way with the Treadways. And the purpose of that is, if you lied once, you won't lie again if everybody that you know is in support of you telling the truth.
Makes sense. Don, I was going through the motion to dismiss, and it seemed like the prosecution had some possible alternate explanations for the presence of Stephanie's blood on Tuitt's shirt.
Yeah, wasn't that creative?
I want to spend some time in this and go through each one of those and get your thoughts. So here we go. Tuitt's shirt could have been contaminated by equipment used at the crime scene. What do you say to that?
Okay, here's the bottom line on the blood that was found on Tuitt's clothing. Remember the knife when it strikes through the comforter into the body and it comes back out? There's going to be blood on it, and there's going to be drops of blood that are going to get on the person that's stabbing Stephanie. You can't have such a close personal attack without having some splatter of the blood onto your clothing as the attacker. That is exactly what was found, blood spatter. A blood will have a different structure, a different formation if it's a splatter. If it's a smudge, it is smeared and loses the continuity of the splatter. So this idea that the tripod for the camera that was at the scene and taking pictures of the bedroom and the dead child somehow got blood on it and later was transferred onto Tuitt's clothing is an impossibility because these were blood splatters, not smears. But more importantly, Tuitt was arrested that same day and taken to the Escondido Police Department after he had been found in the laundromat. His clothing was taken from him. It was folded up, secured, and put into an evidence locker. How in the world can you have a smearing of the blood by the tripod or any other equipment that the police had if his clothing had already been packaged up and put away? Now, the only way it could be done in the way that Summer Steffens wanted to argue it was that there was a storage bin, a large storage bin, the size of something like if you're going to be moving and you pull one of these large bins up and you put all your belongings into it, that is how it got contaminated. The clothing of Tuitt got contaminated. But that theory just fell apart like you couldn't believe it, because there was no way it could happen because the clothing of Tuitt was never opened until the crime lab looked at it.
It sounds like the fact that it is spatter is key here. Don, I thought I read somewhere that the prosecution actually went to Ed Blake's lab and were trying to talk him out of his spatter conclusion. Did that happen?
I don't have knowledge of that. There's a lot of things. Are you saying that the prosecution went there or our expert went there?
I think I read that the prosecution actually went to see Ed Blake to discuss this, and he had to really hold firm and tell them, yes, this is spatter.
Oh, this is the gentleman up in Berkeley. Yes. I must compliment you on your knowledge of the case. That is correct. They actually went up there, and they actually talked to him, and they actually tried to convince him that it was not spatter but a smear.
So here's my question. Once the boys were freed, were they able to get a declaration of actual innocence and any monetary award?
Yeah. After the conviction of Richard Tuitt, I believe it was 203 or 204, they appeared in front, they made a motion in Superior Court and appeared in front of a Superior Court judge. And the judge reviewed all the evidence in the case and did something that is usually never done, and that is he made a ruling of finding of fact that the boys were factually innocent, that they had nothing to do with the murder of Stephanie Crowe, that there was no involvement at all in what the events that resulted in her death. That is different from a not guilty finding. This is a factual innocence that is as conclusive as you can get in law. There was a civil case that was filed on behalf of Michael and Joshua and eventually Aaron. Joshua, the family decided to step out of it. I told you they were deeply religious, and they asked to be dismissed from the case. I believe $4.5 million was awarded to Michael, and the amount to Aaron I think was $3.2 million, something like that.
Don, to kind of round this saga out, talk to us about the interesting procedural history of Tuitt's case and what the outcomes of his multiple trials were.
Well, you've got to look at this from an appellate point of view. The reason the appellate court stated that he should have a new trial after he was convicted was because the judge whom I've known for years, he's a very good judge. He handles all the major criminal cases, ruled that a witness was irrelevant and therefore shouldn't testify. That witness had nothing to do with the case facts that were being presented against Tuitt. But from an appellate point of view, there was no physical evidence in this case in the house showing who killed Stephanie. So they are saying, well, let's have another trial because this one witness was denied and see what happens. That's my interpretation of the ruling of the appellate court. And during the second trial, much to the credit of Tuitt's defense attorney, he was able to attack the evidence of blood and the DNA proof that it was Stephanie's blood because he brought in the head of the crime lab, San Diego crime lab, who swore up and down that there was no way that any blood was on the clothing of Richard Tuitt. In particular, the red outer shirt and the white T-shirt. So what you had was two experts, one saying it's spatter evidence, one saying I saw it right after the murder scene. I examined it, and there was no blood on these garments. And I did a presumptive test, and it did not show any blood. So from a trial point of view, from a trial attorney's point of view, what you've got are two experts that are canceling each other out. And what's left? No evidence, no physical evidence pointing to anybody as the murderer. And then you had confessions of Michael and of Joshua. So it was a very weak case the second time around, and that's why the jury found him not guilty. That's my opinion.
You know, Don, it's really an amazing story and a fascinating book. We really recommend that our listeners read it. We really appreciate your time, and thanks again for joining us on the Crime Redefined podcast today.
Thank you, guys, and thank you for a very thorough understanding of the case.
Don, it was a very interesting hour chatting with you. I really enjoyed the book, and I highly recommend it. Thank you so much.
All right, thank you, guys. Bye.
What a disturbing story. Don's book is a really riveting read, but it sure is troubling.
Yeah, well said. And it's troubling for a number of reasons. One is the tunnel vision or confirmation bias that the investigators developed very early on. So once they locked into this theory that Michael had to have been the murderer, the lens that they looked at all of the physical evidence was really like a funhouse lens at that point. I mean, the ridiculous explanations they came up for the evidence was really unsettling. So it's great that Don wrote this book, and on top of that, offered some suggestions for more protection for children in the system.
You know, a lot of that was really tough to listen to because of, like any human being, you either picture yourself or a family member in that situation, and it's really frightening. They were really trying to, you know, put the square peg in the round hole and make a shoe fit and all that other stuff, and it just really made it hard to listen to. And I'm not really sure there's too much we can add to his interview. He really gave us a thorough account of the issues in the Crowe case. Hopefully this book is a real eye-opener to law enforcement and the prosecution.
Yeah, Dion, I just wanted to share one little nugget from the book that we didn't cover in the interview. And I think that this shows kind of what the community thought about the case at the time. So after it was determined that the boys would be tried in adult court, they were slapped with a huge bail to try to keep them in custody. And apparently, various members of the community chipped in and even put their house up for collateral to cover the bail so the boys could be free.
You know, it goes to show you how much confidence they had in the boys and the family, which kind of leads me to my next comment. If it's not already in the works, there needs to be a major Hollywood movie or at least a television series one-off about this case.
No doubt.
Don's book, She's So Cold, Murder, Accusations, and the System That Devastated a Family is available wherever books are sold. Check out Don's website at donaldmcginnis.com, where you can learn more about Don. On the site are links to purchase the book through Amazon, Barnes & Noble, and indiebound.org. As always, a big thanks to all of our listeners and followers on social media. We hope you both enjoyed and learned from our interview with Donald McInnis. Please be sure to subscribe to Crime Redefined to make sure you never miss an episode.
Thank you for listening to the Crime Redefined podcast. Like us on Facebook and follow us on Twitter at Crime Redefined. Please send us your comments and questions and join us for the next episode.